Hi, this is Mamta Patania. Welcome to the Civil Service Mentoring Program of IIPA. Let's discuss the multiple choice questions on polity and governance. Our first question. Under the Indian Constitution, concentration of wealth violates. You have four choices in front of you. The right to equality, the directive principles of state policy, the right to freedom, or the concept of welfare. So in order to get the exact answer, let's get into the explanation what exactly is the right answer. Now coming to the directives based on socialist principles, that is Article 39, the state shall in particular direct its policies towards securing. Now there are n number of things which you actually have to know. Number one, the right to an adequate means of livelihood to all the citizens. Number two, the ownership and control of material resources shall be organized in a manner to serve the common good. Number three, the state shall avoid concentration of wealth in few hands. Number four, equal pay for equal work for both men and women. The protection of strength and health of workers, and last, childhood and youth shall not be exploited. Now if this goes the explanation and come to the answers which are there in front of us, the question clearly tells under this Indian Constitution which is the thing according to the four options given which actually violates concentration of wealth violates. So here the answer is clearly B. So here the other answers are totally wrong, and the answer is clearly B as per the explanation, that is directive principles of state policy, which actually tells that directives based on socialist principles, that is Article 39. So coming to the question number 2, which tells what is the position of the right to property in India. So very clearly, right to property in India. So we have four options amongst us which clearly tell what is the position of the right to property. So coming to the explanation, right to property actually was a fundamental right in the original constitution under Article 31. So you need to actually know that under Article 31, this was earlier a fundamental right which provided that constitution not only guarantees the right of private ownership but also the right to enjoy and dispose of property free from restrictions other than reasonable restriction. But an interesting point to be noted here is that under the Constitution 44th Amendment Act 1978, so I repeat once again, Constitution 44th Amendment Act 1978, it deleted the right to property from the fundamental rights. Now when we say it's deleted, so herein the third option, that is fundamental rights available to citizens only, is not the option because it was deleted under the 44th Amendment Act. Now another interesting thing which was actually which is important to be noted here is that the amendment also omitted Article 31 and Article 19(1)(f) and inserted in their place Article 300(a). Now you need to actually know what is Article 300(a). Now Article 300(a) actually provides that no person shall be deprived of his property save by authority of law. Now if this is the case, therefore coming and keeping all these explanations in mind, the answer of this question, what is the position of right to property in India, the answer is clearly B, that is right to property is a legal right available to any person. So this is the actual answer of this question. Coming to the third question, what was the exact constitutional status of India on 26 January 1950? So her point to be noted here is exact constitutional status of India on 26 January 1950. Four options are there in front of you, whether it was a democratic republic, a sovereign democratic republic, a sovereign secular democratic republic, or a sovereign socialist secular democratic republic. So in order to come out with the answer, let's actually see. Now according to the constitution at that time, its commencement, that is on 26 January 1950, India was a sovereign democratic republic. Now, when we say sovereign democratic republic, it got the constitutional status of being socialist and secular only after the 42nd Amendment Act 1976. Means in the 42nd Amendment Act 76, the words socialist and secular were added on, and therefore the answer of this question is clearly, when we say at the point of 26 January 1950, the actual status, the exact constitutional status of India was, the option is clearly B, that is, it was a sovereign democratic republic. So here the answer is sovereign democratic republic, and we cut forth all the options, and therefore the answer is B, that is sovereign democratic republic. Moving on to the next question. Constitutional government means. So here we need to actually understand what is constitutional government. Now the number of options A, B, C, D clearly defined in a different manner what constitutional government actually means. So we need to understand, keeping in view the 4 options which are there, a constitutional government is one that is defined by the constitution of the country. A constitution can merely be a set of fixed norms or principles, or a legal instrument accepted in the country as a framework for the polity of the country. Constitution of a country is a supreme law of land, and it is empowered with the sovereign authority of the people, that is we the people, by the framers and the consent of legislatures of the states. It is also a source of the government powers and also provides important limitations of the government that protect the fundamental rights of the citizens. It can also be connoted as a collection of fundamental principles, established precedents according to which a state or other organization is acknowledged to be governed. So its major impact is, limit is that it puts on the sovereign governments on how to rule and govern. So keeping all this background in mind, what actually should be the answer? So the first option clearly tells constitutional government means a representative government of the nation with federal structure. So keeping the explanation in mind, we outrule this. A is not the answer. A government whose head enjoys nominal powers, it's not the answer. A government whose head enjoys nominal powers, not the answer. So the only option left as per the explanation which we actually talked about when we said that a constitutional government is one that is defined by the constitution of the country, and it has powers of the government to rule and govern. So herein the D option is correct. That clearly tells a government limited by the terms of the constitution. So a constitutional government is one which is limited by the terms of the constitution. So this is the answer for this question. Our next question, seeing or keeping in mind the following statements, we'll specifically see what are the statements. We have to answer out of the 3 statements which are given here, which of the statements given above is or are correct. So we need to actually find out which out of the 3 statements are correct. So we'll see these statements one by one. The first statement clearly tells right to the city is an agreed human right, and UN Habitat monitors the commitments made by each country in this regard. Right to the city gives every occupant of the city the right to reclaim public spaces and public participation in the city. And third is right to the city means that state cannot deny any public service or facility to the unauthorized colonies in the city. Now the 3 statements are very much clear in your mind. Now we need to see actually what is the actual answer for this. So we need to be very much clear here that right to the city is a holistic approach to improving the quality of everyday life in cities. The right to city is at the heart of the new urban agenda agreed at the Habitat 3. UN Habitat partners with national and local governments, academia, civil society and the private sector in the implementation and monitoring of the commitment made under the new urban agenda. So the new urban agenda is very, very important, and also the SDG 11. So herein, keeping in this particular thing in mind, statement 1 is correct. Moving ahead, the Universal Declaration of Human Rights commits to social justice through the promotion, defense, fulfillment of all human rights related to habitat, including the human right to adequate housing, law and right to the city in every region of the world. There is also a World Charter of the Right to the City. I repeat, World Charter for the Right to the City, which actually provides progressive framework to rethink cities and urbanization. So it clearly tells World Charter for the Right of the City provides for a framework for rethinking of the cities and the urbanization. So the right to city is the right of all inhabitants, whether present, future, permanent or temporary, to inhabit, use, occupy, produce, transform, govern and enjoy cities, towns and human settlements that are just, inclusive, safe, sustainable, democratic and defined as common goods for enjoying life with dignity and peace. Now this clearly tells that right to the city further implies responsibilities of government and people to claim, defend, promote this right. So keeping this in mind, statement 2 is also correct. So as far as this thing is concerned, the right also claims for around 9 to 10 features which are there. Number 1, the social function of the city, quality public spaces, sustainable and inclusive rural-urban linkages, inclusive economies, inclusive citizenship, enhanced political partnership, non-discrimination, gender equality and cultural diversity. So keeping all these explanations in mind, herein the answer is C, which tells out of the 3 statements, first and 2 are correct and therefore the answer is C, that is 1 and 2 only. Moving on to the next question. With reference to India, we have to consider the 2 statements which are there in front of you. Which of the following statements given above is correct? So here also we need to actually find out of the 2 statements which of the statements is correct, and the options A, B, C, D are there in front of you. So when we say it is talking about judicial custody, it clearly tells means an accused is in the custody of the concerned magistrate and such accused is locked up in a police station, not in jail. And similarly the second statement is there in front of you. So keeping in mind the 2 statements which are there in front of you, we have to know what actually is the position. So here we need to understand the provisions for custody in India are governed by section 167 of the Code of Criminal Procedure. Which section I am mentioning here? Section 167. Section 167 of the Code of Criminal Procedure actually provides for the provisions of custody in India, and this is governed by this section. A person may be held in the custody of the police or in a judicial custody. The first thing that happens to a suspect on arrest is that he is taken into police custody. Now, while this is going on, following which he is taken before a magistrate. From there, he may either be remanded to judicial custody or be sent back to the police custody. So we need to understand under this section, it clearly tells the procedure how this thing is actually going on. The police custody means that police has the physical custody of the accused, while judicial custody means an accused is in the custody of the concerned magistrate. In police custody, the accused is lodged in police station, lockup, while in judicial custody, he is locked up in the jail. So the difference between the 2 is clearly brought out by this statement. Therefore, the statement 1 is incorrect, which clearly tells that it means accused is in the custody of the concerned magistrate and such accused is locked up in the police station, not in jail. Similarly, during judicial custody, the police officer in charge of the case is not allowed to interrogate the suspect. However, the court may allow the interrogations to be conducted if it opines the interrogation being necessary under the facts procedures before the court. So therefore, this statement actually brings out the fact that statement 2 is basically correct, which tells during judicial custody, the police officer in charge of the case is not allowed to interrogate the suspect without approval of the court. So when the two statements are clear, however, during police custody, one thing important which actually needs to be taken care of is that the police officer in charge of the case may interrogate the suspect. So herein, keeping this these particular things in mind, the answer of this question is B. B is that 2 only. So herein, during judicial custody, the police officer in charge of the case is not allowed to interrogate the suspect without the approval of the court. So here the answer is B. Moving on to the next question. Keeping in view the two statements which are there in front of you, when a prisoner makes out a sufficient case, parole cannot be denied to such prisoner because it becomes a matter of his or her right. And number 2, state governments have their own prisoner release on parole rules. So keeping these two statements in mind, we have to answer, and the question here is which of the statements given above is correct. So here again we need to find out which amongst two statements is correct. We have A, B, C, D, 4 options. So let's see the scenario here. State governments, we need to understand, have their own prisoner release on parole rules. Prisons is a state subject under the state list of the 7th schedule. So we need to understand here that prisons is a state subject, and under which list? It comes under the state list under the 7th schedule. So state list is one thing which one needs to be clear of, and it comes under the 7th schedule of the Constitution. So 7th schedule is very, very important here, which actually defines the prisons under which subject it comes. So herein, keeping this in view, statement 2 is correct. Statement 2 clearly tells the state governments have their own prison release on payroll rules. Coming to the next statement, here we need to know the management and administration of prisons fall exclusively in the domain of state governments and are governed by Prisons Act 1894. Which act? It's Prison Act 1894 and prison manuals of the respective state governments. So herein, this is very, very important to be taken care of. And the third important aspect here is the Prisons Act further says, it actually says that only states can make rules regarding release of prisoners on furlong, parole and remission as part of correctional process in jail reform. So keeping these explanations in mind, it clearly tells the answer is B. That is 2 only, because we need to find out of the two statements which one is correct. So herein we outrule the other answers, that is A, C and D, and the correct answer is 2 only. Moving on to the next question. Now here the question is, at the national level, which ministry is the nodal agency to ensure effective implementation of scheduled tribes and other traditional forest dwellers recognition of forest rights Act 2006. So keeping this question in mind, there are 4 options given. There are different ministries given. Number 1, Ministry of Environment, Forest, Climate Change, Ministry of Panchayati Raj, Ministry of Rural Development, Ministry of Tribal Affairs. Any guesses to the answer? So let's see this question. We need to understand that Ministry of Central Government dealing with tribal affairs or any other office or authority is authorized by the central government in this behalf shall be the nodal agency for implementation of the provisions of this Act. The Forest Rights Act, that is the FRA 2006, it clearly recognizes the rights of the forest dwelling tribal communities, other traditional forest dwellers to the forest resources on which these communities are actually dependent for the variety of needs, which actually includes livelihood, inhabitation and other socio-cultural needs. So when we clearly see what Forest Rights Act, that is the FRA 2006, it clearly tells out of the 4 ministries which are mentioned here, the national level, at the national level, the ministry which is the nodal agency to cater to this, the answer clearly is D, that is Ministry of Tribal Affairs. Moving on to the next question. The question tells a legislation which confers on the executive or administrative authority an unguided and uncontrolled discretionary power in the matter of the application of law violates which one of the following articles of the Constitution of India? So here we need to find out it violates which one of the following articles of the Constitution of India. 4 articles are given: Article 14, Article 28, 32 and 44. So we need to understand one by one. Looking at the first article, that is the Article 14. Article 14 of Indian Constitution, it clearly says that a state shall not deny to any person equality before the law or equal protection of laws within the territory of India. The concept of equality before the law is an element of the concept rule of law, which you all might be aware of. Now, this concept has the following 3 important elements or aspects which actually you should keep in mind. Number 1, absence of arbitrary power. Number 2, equality before the law, that is equal subjection of all citizens to ordinary law of the land. Number 3, the Constitution is the result of the rights of the individual. And the first and the second elements are applicable to India. This means equality before law under Article 14 connotes that the absence of arbitrary power with the authorities. Thus, when a legislation confers uncontrolled discretionary powers to any authority, it tends to violate the Article 14 of the Constitution. Now, this actually clearly comes out with the answer. The explanation clearly tells, herein, keeping this in mind, the answer is A, and it outrules the other articles, that is Article 44, 32, 28. So, the clear answer is Article 14. Herein, the answer for this question is A, that is Article 14.